Hello, this is Charles Green, and I'm here today to do another video to explain to you some legal issues about family law. My name is Charles Green. I'm a certified specialist in family law here in Los Angeles, California. And today we're going to talk a little bit about what happens when your divorce starts. So, what does that mean? You have hired an attorney. Hopefully you've hired me. And we get some information from you. We give you questionnaires. We interview you. We listen carefully to what your concerns are. And that information has to be put into specific forms here in the state of California, Los Angeles County, to turn your divorce into what they call a legal pleading. The pleadings that start your divorce case here in Los Angeles County consist of a summons and a petition. There would also be some other documents if you have children. There will be something called a UCCJEA form, which has to do with whether or not the county and the state have jurisdiction of your children. But today's today's video is a discussion generally about what these forms are for. Okay, what is the information in these forms trying to communicate to the other party and to the court and to you? What are you trying to communicate to the court, to the other party, with these forms? So, the summons is the basic form that has kind of like the rules. And the summons, which is issued by the court, has an automatic restraining order on it. So, when you file your divorce case, you are subject to what's called standard family law restraining orders. And what these restraining orders are things like you can't take the minor children out of the state. You can't cash, borrow, cancel, transfer different types of financial instruments. You can't change beneficiaries on life insurance. You can't change the coverage on the health, automobile, or disability policies. You can't transfer or encumber your assets. In other words, a lot of people think they're very smart and that they have some sort of original idea on how to beat the divorce process. Well, it's highly unlikely because millions of cases have come before you, have come before the appeals court, and there are remedies for all the types of games that people want to play, for all the assets they think they can transfer to a friend or a brother, and there will be consequences, financial consequences, that will befall you when these things are unraveled. So I would say to you, if you're going to be in a divorce case, carefully read these restraining orders that you'll find on the back of the summons. Now, they apply to you when you file your petition, which is the next document we're going to talk about, and which is the document we're going to spend most of our time talking about in this video. These standard restraining orders on the summons, they apply to you when you file your petition, or when your attorney files the petition you signed on your behalf in the courthouse. So it's not enough to say, oh, I didn't know. They apply to you when your petition is filed. And they apply to your spouse when he is served with the summons and the petition that is conformed by the court. Conformed means stamped. And conformed also means that your case got a case number. Okay, because this is how your case starts. So we talked about the restraining orders. So when you get served with that petition, make sure you read the restraining orders carefully. When you hire an attorney and you sign your petition, make sure you say to your attorney, can you go over the restraining orders with me, the standard family law restraining orders, so that you don't inadvertently, accidentally do something like take your wife off the car insurance, take your husband off the health insurance. If you do that, there's consequences because the restraining orders say you can't do it, okay? And even if you think that you're going to be smarter than the restraining orders and do it before the case is filed, well, then it's just a breach of fiduciary duty and you'll still have consequences. So don't think that you're going to outsmart the system, okay? Don't try to butt your head with the system, okay? Flow with the system. Don't try to go against it. There will be financial consequences that will be a reckoning to you some point in the dissolution process. Okay. So, a little bit more about me before we get into the petition. I'm a certified family law specialist. Okay, that means I have done a lot of divorce cases, a lot of child custody cases, a lot of support cases. My specialty is complex family law cases, and I also have an extensive financial accounting background, so I'm very well suited for high asset divorces or complex divorce cases. If your spouse has his or her own business or complicated compensation plans, this is the right office for you, because there's very few family law specialists in California that have had previous career experience as a certified public accountant as I have. I worked for 10 years as a certified public accountant before I became a family law attorney, and now I'm also a certified family law specialist as an attorney, in addition to having the financial background. All right, so now for the main topic of this video, that is the petition. The reason I decided to do a little video about the petition is because many people over the last 20-something years that I've been doing this have contacted me, and they're very upset about what's in the petition. All right. The petition is essentially a jurisdictional document. The petition is a document that has several different categories. Okay. Divorce in California is divisible into different topic areas. Those topic areas can all be found in the petition. And people sometimes get upset about what their spouse checked or wrote in the petition. All right. The petition is the way for the court to have jurisdiction on the different topics that make up a dissolution of marriage case. For example, the status of your marriage, that is part of the petition. So that's why, number one, we are married, legal relationship. Okay? You could also be domestic partners. So you check the box to tell the court what it is you want them to decide. You want the court to decide that you were married, okay? Maybe that issue will not be contested in the response that your partner will file, all right? Then there's the residency requirement. The petition establishes that you have been a resident of California for the past 6 months and a resident of the county of Los Angeles for the past 3 months. These are the jurisdictional physical requirements of filing in Los Angeles County and the state of California. Then there's the statistical facts of the marriage, date of marriage, date of separation. Now, why are we putting these things on the petition? Because this is what we're giving notice to your partner. These are the basic facts that we want the court to prove, and that we want to prove to the court in the divorce case, in the dissolution case. And the response document could agree with some of these items or disagree. But at least we know what are the topics that the court has to decide later on at a trial, which is how the divorce ends. All right. But before the trial, there could be mediation through the court. There can be different types of mediation conducted by the two attorneys, informal mediation, settlement communications, and whatnot. All right. Another item on the petition is the children and their date of birth. All right. You could argue, no, those are not my children, or you could agree on your response. But one of the most important areas on the petition that people get upset about is the date of marriage, date of separation, all right, because there's consequences for support and other property rights that depend on the date of marriage and date of separation. So be very careful and think it through and talk very carefully with your attorney about what does it mean if we have a different date of separation. For example, if you're married and were together for more than 10 years, then the jurisdiction over spousal support could be ongoing, all right, for the rest of each of your lives until the recipient of spousal support remarries or passes away. So the date of marriage and date of separation is very important. Also, let's say you have some sort of retirement account, all right? Money is being added to that retirement account as community property until the date of separation. Once the date of separation is established, then any money put into your retirement account would be separate money and not part of the community and not divided as part of the divorce. So the information in this petition is very important. Now, many people get upset by the spousal or domestic partner support, spousal support, otherwise known by some as alimony. All right. It is common that when people fill this out, they would put that I, as petitioner, want spousal support, and I don't want to pay spousal support. I want the court to terminate spousal support to respondent, my partner. This upsets people very much, and it's upsetting people because they don't really understand this, what it means. All this means is that by checking these boxes in spousal support, that the court now has the authority, the ability, the right to make decisions about spousal support in your case. Similarly with child support, they don't even give you a box because if you have children, the court wants to have the authority to decide the child support. All right. Now, getting back to the spousal support. So I put here that I don't want my spouse to get support, that I want the court to end its jurisdiction for spousal support for my spouse. All right. Now, my spouse is going to put on the response paper, no, I want spousal support, and I don't want to pay my wife's spousal support. Okay. So that means the court has to decide it because there's no agreement. All right. If you don't answer these papers, if you allow yourself to get into default, and you have 30 days after you are served to respond to the petition by filing a response, if you don't file your response, then you are in default. And when you are in default, what is in the petition will end up being what's in the judgment. All right? Most of the time. So if you put there, if the petition says terminate your rights for spousal support, and you don't file a response, the judgment may very well say that your rights to receive spousal support have been terminated. And if you were a housewife for the last 18 years and you decided not to file a response because you just didn't want to deal with this difficult task of filing divorce papers or meeting lawyers and whatnot, and the expense involved, well, then you just lost your right to spousal support. And that could be 10, 20, 50 times what legal fees would have been to do this properly. So, while it is a very difficult emotional thing to deal with a divorce, your obligations to yourself and to your children, your financial responsibilities, require you to put your emotions in check and deal with this in an adult manner, okay? Or else there'll be financial consequences, legal consequences, which can affect you, your children, and other people in your life. So you have to deal with this, unless you already have a understanding with your spouse that you're going to proceed by default for some reason, such as it's a very short marriage and a no asset case. All right. Another area on the petition that upsets a lot of people is attorney's fees. Attorney's fees. This is probably the number one reason that people call me upset about the petition. All right. They call and they say, my wife checked the box that she wants me to pay the attorney's fees, and I don't want to pay them, and what's going to happen? Well, just as a little bit of a review, checking the box on the petition does not cause something to automatically happen. It is just opening up the court's jurisdiction to make decisions. For the court to make a decision, you have to file other papers. There's different types of papers get filed at different points in the divorce process. There are temporary orders, which are called RFOs, requests for order hearings, and there are permanent orders, which is what happens at a trial and a judgment. So, by checking the box for attorney's fees, that has opened up jurisdiction. That means that when the case starts, the person that wants attorney's fees can file an RFO, request for order, saying, I would like a contribution to my attorney's fees, Your Honor. I am a housewife. I stayed home raising the children, and my husband is a tech executive, and he makes all types of money, and I need him to help pay my attorney's fees. Well, you're in luck, because in a situation like that, there is a statute, Family Code 2030, and that statute requires the court to give a contribution of attorney's fees to a spouse like a housewife that does not have access to money or doesn't have anything but community funds available, and you're out there earning 10, 20,000 a month, okay, or even 5,000 a month. The court will order you to contribute to your spouse's attorney's fees if you are the spouse that is generating income, okay? There's no way around that. So any attorney that says you won't have to contribute to your partner's attorney's fees if your partner is the non-earning or low-earning spouse, and you are the primary earner, the court has to give an award, okay? 10 years ago, the court had more flexibility, but there has been case law. It's come down that requires the court now, requires the judge to make the playing field equal for attorney's fees. Now, it's never going to be truly equal if one person is earning a lot of money has access to a large part of the community or separate property, and the other person is barely getting by on spousal support or child support and is asking for attorney's fees. It's never going to be actually equal. But what we have seen, just as a general rule of thumb, is if initially you paid your attorney, let's say, a $7,500 attorney fee to start the case or whatever, usually that'll match what the first award of attorney fees will be to your partner. And this information is all disclosed to the court on the income and expense declaration forms. So the court will know what you paid your attorney, and it is likely, but not certain, that something similar to what you paid your attorney is what you will be ordered to pay your spouse's attorney if there's an imbalance in the ability of each party to pay attorney's fees. Okay, so that's the last item on the petition. But going back up, we also have separate property and community property listings on the petition. All right, so separate property would be if you had a house or a bank account or retirement account before marriage, you would want to list that as your separate property. If you don't list it here in the petition and you have a contested divorce and your partner's participating, it's okay. But if it's a default divorce, and you didn't list something that is your separate property, well, then you're going to have an additional hearing after the default judgment, okay, an omitted asset hearing on everything that's not in the petition. So without getting too complicated here, you have to make a decision with your attorney about the amount of information that's going to be on the petition. If you anticipate this will be a default judgment, you want to get as much information on there as possible. If you anticipate that your spouse is going to participate in the divorce process, then it's less crucial to list out all your separate or community property on the petition. There's less consequence. However, as to real estate, okay. There are a lot of litigants out there, especially in family law, that think they're going to outsmart the system. All right. And a lot of the things that a family law attorney can do to prevent those type of activities are actually helpful to the spouse that is not in control of the assets, and also the spouse that is in control of the assets, because all that happens when someone tries to manipulate the system, transfer assets, is they're going to increase the cost of the divorce, the amount of time involved, and the attorney's fees involved. So if the attorney, through writing a skillful petition, can stop some of the activities that would frustrate the easy settlement of the case, that attorney is helping both you, their client, and the other party, because by writing a proper petition that prevents manipulation of the assets, the costs of the case could be reduced. So the point I'm trying to make here is specifically as to real estate. Real estate listed on the petition can have what's called a list pendants recorded on it. If a piece of real estate is not listed on the petition, you don't have a right to record a list pendants on the real estate as part of the divorce case without permission from the court. Now, what is a list pendants? Simply stated, a list pendants is a cloud on title of real estate related to this divorce case. It would have the case number on a simple statement that is recorded at the county recorder's office. and it is essentially notice to anybody that would want to refinance, like a bank or some sort of lender or a future buyer, to not buy, not refinance this piece of real estate because it is involved in a litigation. All right. So a lis pendens will prevent, most of the time, the the spouse that has control of the property. In other words, if it's recorded in one person's name, and sometimes even if it's recorded in both names. Back around the 2006 time, we saw a lot of people able to get lines of credit on real estate, even if it was recorded in both names. One party would be able to get a line of credit. But if there's a lis pendens, none of that should happen, all right? Because the lender or the purchaser of the real estate is been made aware that this case is involved in a litigation, the divorce. So lis pendens is a very important thing, but you cannot record a lis pendens unless the real estate, the address, is clearly indicated in the petition. So the petition is an extremely important document to open up jurisdiction on the different areas of divorce, and it's also very important to stop the transfer of real estate. It's the first step in freezing real estate for the case, and it's also important for the crafting of a default judgment. So the petition, the document that starts your divorce, very, very important, even though it's just a few pages. And it's very important when your attorney drafts the petition, you should carefully go over it with him or her and understand it. Understand the petition before you sign it and file it with the court. So, again, my name was Charles Green. Okay, I'm a certified family law specialist, an attorney here in Los Angeles, California. And I'd be happy to consult with you about your case, whether it's a new case or an ongoing case. You can contact me here at the law office of Charles M. Green. The phone number is 213-387-4508. Again, you can contact me at 213-387-4508. That's how most people initiate the hiring of this law practice of the lawyer Charles M. Green. For their divorce case, most people call us up, and irregardless of the COVID problems, we talk over the phone, and we get to know each other and learn about different issues in your divorce, and you can hire us. So we can do everything remotely now, and we can go to court remotely. We can deal with the clients remotely, and you can hire us remotely, and we'll figure out what everybody's comfortable with, and we'll figure out how to give you good representation and keep everyone safe from the difficult times that we're in right now, okay, with the COVID. But people are still getting divorced, lots of people, and they need legal representation, and we're here to help. Okay, thank you very much, and I hope to hear from you if you need our assistance.